The coin's market cap is the basis for the video's explanations. Additionally, watch this right now if you want to stay up to date on XRP and other cryptocurrency news by subscribing to my channel and liking it. Oh, the XRP litigation might come to a close if the SEC misses the appeal deadline. Right now, on Telegram, there is a new crypto airdrop that I would like to inform you about. It's about to go live at any moment. You must not miss out on this airdrop. The link is in the description of the video. Take advantage of this chance. Okay. Our video is going to begin now. There may not be enough time for the CC to challenge Ripple's decision. When to file an appeal with the SEC is a contentious topic among Bitcoin ecosystem participants. The frequency of XRP encounters increases as the appeal deadline draws near. Many have speculated about what might happen if the SEC fails to file a probable appeal in the Ripple case by the deadline, based on the opinion of a well-known analyst. Forecast today, October 17th, the SEC will file an appeal. The commentator claims that many in the cryptocurrency industry would be taken aback if the agency chose to appeal. Despite widespread belief among Bitcoin enthusiasts, he claims the SEC is actively working to ensure that October 17th is actually the deadline. The deadline for filing SEC Form C is quickly approaching, which lends credence to the October 16th deadline, according to cryptocurrency lawyer Jeremy Hogan. Hogan attached a screenshot illustrating the required pre-argument statement for a civil appeal. Could halt the XRP litigation if Ripple fails to meet the SEC appeal deadline. Ashley Prosper, a prominent member of the XRP community, has cleared up some confusion regarding the Ripple v. XSEC appeal deadline. Many members of the XRP community are currently discussing the unknowns. The real due date is causing a lot of confusion. It is suspect that the SEC missed the deadline when they first raised the question of appealing, and the situation is becoming hotter by the day because the State Securities and Exchange Commission's Forum has varied interpretations of three important documents. We need to get our hands on the most important documents so we can figure out what happened. The form of a document was established by its acknowledgement of receipt and notice of appearance. On or before October 18th, the deadline. A confirmation of involvement in the lawsuit is the primary purpose of this document. Having said that, Form C's due date is completely unrelated. The records of the Second Circuit docket are shown in Document 2. Relying solely on the docket dates of the Second Circuit could lead to incorrect schedule extensions due to technological delays, as Prosper points out. Because of this, the precise due date might get murky. Prosper considers the District Court docket, the third document, to be the most important document. There is no more crucial paper than this one. With evidence pointing to an October 2nd notice of appeal, Form C had to be submitted to the Securities and Exchange Commission no later than October 16th. If you believe Prosper, the SEC was late because of this specific date. The due date for filing with the Securities and Exchange Commission seems to have passed. According to Prosper's findings, the 14-day countdown started on October 2nd and will conclude on October 16th. The public is worried that the SEC website won't be able to get everything done in time. Even though people don't necessarily think that missing the deadline typically results in the dismissal of the case, they are aware that there can be consequences such as warnings or fines. A former SEC attorney named Mark Fagel provided a different viewpoint, expanding on the loose compliance with the 14-day deadline. What the courts decide on the duration of it is up to them. While the deadline has passed, he assured the public that the state CCC will not abandon the appeal. The notice of appeal was filed by the Securities and Exchange Commission on October 2nd, so that the agency can challenge the $125 million judgment. There may be time for the SEC and its constituents to submit the necessary paperwork since the subject was placed on the Second Circuit's docket on October 4th. If the SEC had required additional time, Prosper argues they should have requested it. The SEC may view the failure to meet the deadline as a serious procedural error if no acceptable technical explanation can be provided. Meanwhile, kick the ball. Fox Business journalist Eleanor Tourette reported that attorneys, including the former Ripple general counsel, initially believed the SEC deadline was October 16th. However, attorney Jeremy Hogan and Tara later clarified that the actual deadline is October 18th. Tara was also made aware of this since the appeal would not be docketed until October 4th. It is common practice to start the 14-day clock from that date rather than the claim submission date. Everyone in the XRP community is confused about what to do next and what this means for Ripple because there is no clear consensus and a wide range of opinions. The relationship between the cryptocurrency market and the SEC is still being worked out. A lawyer who is an XRP representative Rispoli has provided an overview of the information that will be included in the forthcoming Form C filing by the United States Securities and Exchange Commission. Details about the agency's desired appeal strategy in the ongoing case with Ripple Labs are expected to be provided in the form. Keep going. The submission of the SEC's pre-argument statement is something that Rispoli is absolutely certain will happen, even though many in the community are unsure. On August 7, 2024, Judge Torres handed down his final ruling regarding the matter that involves Ripple and the SEC. The notice of appeal was submitted by Ripple earlier this month. In response to the court's decision to fine Ripple Labs $125 million for selling XRP to institutions, the SEC decided to take legal action by appealing the decision. Ripple has retaliated by filing a cross-appeal with the appropriate agency. To prevent the SEC from achieving its regulatory objective, Ripple CEO Brad Garlinghouse has stated that the company is engaging in all necessary actions to undermine the SEC. Additionally, the company is defending itself against the sexist allegation that investment contracts are not legal. In addition, as Alderati noted, the SEC's appeal lacks a solid legal foundation. He thought Ripple would win the case if it went to court. As of October 17th, the SEC has still not turned in Form CU. Ripple will do so then. You have a full 7 days to submit Form C, which provides further clarification regarding its cross-appeal. Subsequently, a gathering will be called to order in order to shake hands and schedule the briefing. Within the next 3 months, the initial brief should arrive at the SEC. After that, Ripple will provide the agency with its own brief. In Fred Rispoli's opinion, the data provided is not intended as a trading recommendation. In his remarks about the ongoing case, he cited a Securities and Exchange Commission Form C, which states that we are not liable for any investments that may have been made using the information on this page. Before making any investment decisions, it is wise to seek the advice of an educated expert and conduct your own research.